everyone. This is Gina Lorenzo with Remax Executive. Thank you so much for joining us today on our podcast. I'm here with Kurush, our CFO, and we're going to be talking about intentional ignorance. Super exciting stuff, very important. So let's just dive right in. So first of all, what is intentional ignorance? Well, first of all, it is a real term. It's also called willfully ignorant, deliberate ignorance. It just means I don't want to know. So before we get started, I do want to clarify that this is not legal advice. Think of this more as just best practices from your broker in charge. And if you feel like you need an attorney, I'm really sorry for your situation, but please don't call me. Why would somebody want to be intentionally ignorant? Usually agents will do this when they don't want to disclose something. They believe if they don't know about it, then they don't have to disclose it. So let's talk about a common case scenario where this comes up over and over again. You're a listing agent and you have a home that you just put under contract. Buyer does a home inspection. You 24 hours after the home inspection, you get a termination of contract. Now comes the question, as the listing agent, do you have an obligation to find out what was in that inspection report? Our answer is, it depends. If the buyer's agent says that they are terminating because of deficiencies with the property, then the answer would be yes. If the buyer's agent says they're terminating for another reason, so say, for example, they just had a change of heart, then the answer is not necessarily. But what happens if they terminate and they don't really provide a reason, or it's sort of gray? My opinion is that an agent does have an obligation, a legal obligation, to at least investigate whether or not there are deficiencies with the property that weren't apparent to the agent when they did their initial walkthrough. If the circumstances suggest that this termination was a result of deficiencies with the property, then as an agent, you do need to do more due diligence. So you're probably asking yourself, well, why do I have to do it? Because legally you're required to. It's in our North Carolina licensing laws. It's Chapter 93, and it requires an agent to discover and disclose material facts. So not just disclose material facts, but also discover. So as a broker, you can't use as a defense to this legal obligation the fact that, well, I didn't know about it, if you have the ability to know. In fact, not only is it not a defense, you can be held responsible for knowing what you could have found out with just some reasonable due diligence, and certainly asking for a prior home inspection would be considered reasonable due diligence. So you need to take it seriously, folks. You've got your licensing rules. You also have your ethics rules that come into play here. And what happens if you violate Chapter 93 and you don't disclose something that was material? I don't think a lot of people are aware that under your licensing rules, when you violate anything in Chapter 93, it's actually considered a Class 1 misdemeanor. So not only are you going to get in trouble with your license and your ability to work in your profession, but you're also going to have a criminal conviction. So this is something that agents need to pay attention to, and Kurush is going to talk about what happens if you feel like you may have yourself in a situation. What we don't advise is putting your head in the sand and hoping that the situation goes away. What you should do is come and talk to Kurush or come and talk to myself, and we can decide whether or not we need to get our insurance company involved. Kurush, what do you want to say about that?
Absolutely. I want to say hi to everyone first. Since we're talking about legal stuff, I want to make a full disclosure that I'm a last-minute guest on this podcast. I think our other guest speaker, something came up and she had to cancel last minute. So I want to apologize because I'm not fully prepared for this, but I would love to talk about this since I'm personally involved in most of our E&O cases. You have several resources if you feel like you're getting into a situation and you need to get some direction. Definitely reach out to your broker in charge. My suggestion would be to first talk to the broker in charge, but understand that how many resources you have available to you. We normally call the hotline, the North Carolina Association of Realtors has a hotline for all the brokers. It's paid for. You guys are paying part of your dues to get that service. So make sure that you have that number handy if you have any questions, any issues. But we also want to talk to you about our insurance, insurance coverage and the legal advice that is available to us. If you received an inquiry from the commission, we would like to engage our real estate attorneys involved to help you to draft a response. So in addition to the sources that are available through the NCAR, we have legal support. So we like to help you to draft a response. Never try to write up something on your own. I've seen some of the brokers, they write 3 pages of email in response to an inquiry from the commission. And to be honest, sometimes you're giving up too much information and you kind of hang yourself in that situation. The people that are usually, you see their names on the inquiry from the commission, they usually sign the letter as investigators. They're attorneys. They're licensed attorneys. Typically, North Carolina Real Estate Commission and South Carolina Department of Labor, they have attorneys in charge to investigate these consumer complaints. So it's best to have another attorney handle the correspondence and handle the cases. That would be my first suggestion.
Everything that you put out there can and will be used against you. So you may think you know what you're doing, but you should really be talking to an attorney who can help you draft your response.
Absolutely.
So that you're not digging yourself into a bigger hole. So so let's go back to the home inspection report. It's not the actual home inspection report that is a material fact. It may be items in the home inspection report. So I know there's a lot of misunderstanding out there with regards to home inspection reports and the agent's obligation to pass, whether somebody got a pre-inspection done or it was a situation where it had been under contract and the previous buyer had gotten one done. Is there an obligation for the buyer's agent to get that home inspection report, or the listing agent to provide that information to any prospective buyers? And the answer to that has actually been addressed by our association, by Will Martin, who said that no, a home inspection report is not in itself material, not something that you have to give to a prospective buyer. What's material is if there are deficiencies that would be considered material fact. If they have not been fixed, then that's what has to be disclosed. But an actual home inspection report, there's no obligation for an agent to provide a home inspection report. So, but then there's, okay, what you have to do, and then there's just, good business. So as a listing agent, if that home goes, if you're under contract and the buyer has a home inspection done, and they decide to terminate, what I do with my clients is if something came up, then we withdraw the home or we'll take it temporarily off the market. We'll get those items fixed. I'll put it back on the market. I always advise my clients to let me provide that home inspection report, which I then also provide all the receipts to show that we got all of these things repaired, because it's about creating trust with the buyer. And if you're only providing just a snapshot or just snippets of what was in the home inspection report, they don't trust you. So I think it's best practice, if you can get the seller to agree for you to release the home inspection report in its entirety, that's really the best course of action in terms of just being able to get the house sold. And again, making sure that those repairs were addressed. So another question we get all the time from agents is, what exactly is considered to be a material fact? And why there isn't just some long laundry list of, here is what a material fact is and here's what you have to disclose. And so there isn't, because that's just the way that the law is written. So under Chapter 93, you've got an obligation, a legal obligation to discover and disclose material facts, and that's about all it says. It's pretty broad. And then in terms of, well, what exactly is considered a material fact, that's a matter of case law And then also we get, you know, opinions from the commission. You get information from your continuing ed classes, but that's about it. So if you feel like, hey, I'm really uncertain as to what is a material fact, well, that's completely understandable. But in terms of, is there some place that some resource you can go to and go down the checklist and say, here's what's considered material, there isn't. And part of the reason for that too is that in some situations, something may be considered material in a certain fact pattern and not material in another fact pattern. So for example, I had a client just recently who wanted to purchase a home that had some land that their intent was to raise llamas. So knowing this, it was really important for me to do my due diligence and figure out were there going to be any either HOA restrictions or city ordinances that didn't allow llamas. So it was definitely a tough property to find, but I did in fact find them one. But I would not say that llamas on their own are a material fact. So in terms of if you don't know if something is a material fact, again, if you have any questions, call me, call your broker in charge, and again, err on the side of probably disclosing rather than not disclosing.
Yeah, I want to share a quick story while we're on the intentional ignorance subject. A real case, one of our brokers was representing the buyer, and this is about 2 years ago. Making a long story short, the buyer, after inspection, they found that there were damages in the basement, there were signs of water intrusion, and this was something that the agent should have known. Even just going through the property, walking through the property, taking the pictures, it was impossible for somebody to walk into that basement and not see the watermarks. And it was some problems with the property, water getting into the basement. I personally had a conversation with the listing agent because the buyer wanted to terminate, and the agent was very arrogant about this whole thing. And this is what he shared with me, you know, that made me report him to the commission. He said, I never order pre-inspection because I don't like to look at that report, and if there's something in there that I don't like, I'm going to have to disclose.
Right, and that again, that's probably the whole crux really of this podcast is we get that situation over and over again, and we have to remind agents that it's not just to disclose what you know, but it's an obligation to discover. You are selling either land or you're selling a home. And it's a lot more than just let me put the sign up in the front yard, put my blinders on so I don't know anything about the house and sell it. I ask sellers a lot of questions, a lot. And it's usually over a period of time. I'll think of this and I'll kind of drill down with them too. And then I will send, a lot of times I will send those same questions to them through an email and make them respond back to me in writing. So that I have a record of that in terms of what they represented about the property. But I think if there's a mistake that I see that agents make, especially new agents, they just don't spend enough time at the property and they don't really walk it carefully and really look at it. And I don't try to do that all at a listing presentation. So I'll go and I'll do my initial walkthrough, but I will come back and I don't necessarily need the seller there. You know, for me, it's just walking and looking. So you need to be looking at the exterior. Do you see stair stepping in the brick? Do you see standing water someplace? You know, do you see places where like the gutters look like they're overflowing? There's all sorts of things that you can look for and not have any kind of construction background and just know, hey, something's not right here. So in terms of you need to know what's going on with that house and not put your head in the sand. Is the commission is going to hold you, you know, responsible or have the knowledge of what you could have done through just simple due diligence.
They'll simply look at us as professionals in the business, and the whole, I guess, principle for the real estate commission and how they approach these complaints, the consumer complaints, they're going to focus on competency. And every time that they basically want to respond and point out where you missed or point out to you the omission, They're always going to reference some of the education material. They reference the year that was in your update class. You know, I've seen enough of these master colored envelopes that I can tell you there are some common patterns in most of them, but they usually come back and remind you that this was part of your education. You've been licensed for the past 10 years. In year 2018, 2019, or maybe 2015, Chapter 1, Chapter 2 of your education book covered this, so you can't say I really did not know. So there's higher expectations from brokers as professionals in the business, and like Gina said, you need to understand your duties, and we're not private investigators, but we also have a duty to pay attention and discover things that are considered material fact. You know, again, simple things. If you're walking the property, if you're seeing something kind of unusual that is a sign of damage, you can't just turn your head away and say, well, I didn't see that.
Well,
that'll be intentional ignorance.
It's intentional ignorance, and especially in North Carolina, where our contract is an as-is contract. I think that the obligation is even higher. So in terms of the obligation for disclosure, and we know that the seller's obligation is different from an agent's obligation. So, and what I've also seen over and over again is that the courts will not side with an agent if the seller made a representation and then the agent believes that. You can't necessarily really even rely on that. If it's something that, again, you could have discovered just through your own reasonable due diligence, even if the seller told you, well, it's not a problem, or flat out lied about it, if it's something that was reasonably discoverable by an agent, you're not going to be able to use that as a defense. Just think of it as you're completely separate from them, your own legal obligation with that. So there's lots of information, there's lots of resources out there. There isn't one source. And I think, again, that's what agents really struggle with is, you know, where can you really drill down and find out, what do I have to disclose, what do I don't? But I think what we really want to talk about today was that home inspection reports are not in and of itself a material fact, and clue reports also are not considered to be a material fact. That's also been discussed by the legal team for our association.
And Jen, I really like the library of the Q&As with NCAR, and honestly, sometimes I go back and read those articles and question answers over and over. If
you're not getting those emails, I think they come out monthly. I think they might even be 2 times a month, and it's the legal questions that are put out by our association and then answered by, typically it's Will Martin, but by their legal team. They are so fabulous. If you are not reading them, you need to be reading those each and every time they come out. And I'm like, Kurush, I actually save them. I save them and I reference them back. So I've gotten saved for years because they're fantastic. And then if you've never reached out to those people, it's free. It's free and it's awesome. And they're really quick when you send them an email. Usually I get a response back within 24 hours. And a lot of times they'll even just call me. So they're a fantastic resource.
As a follow-up to this podcast, maybe we can send out an email with a link to the library of all these, I guess, the forums, and also some direction how to get in touch with Will Martin if you have any questions. There's a hotline. You're going to need your NRDS number and your license number before you make the phone call.
Yeah. So, and you can also send them an email, and that's where they get those fact patterns from, is from agents who have called in with specific situations. So hopefully that has cleared up some confusion for agents with regards to your obligation to share a home inspection report. Just in summary, you don't have to share the report. You have to share things that are material within that report. And the best way to show that it's not material anymore is to show that it was repaired, which you can do by showing receipts. And so, for example, like if you have a seller who, while you're at the listing table, does disclose something to you, so maybe they have mold in their crawl space. Well, we did have that issue with, a foot of water in the crawl space, and we had some mold, but we got it all fixed. That's probably not going to be sufficient to say that it's not material. What would be sufficient is that you get receipts that show that professionals actually did correct the problems. It's even better if there was a warranty or something like that, but just the seller's word that they got it fixed is probably not going to be sufficient. You need to, and it's okay to ask a seller, well, I'm going to need documentation. Because again, it might seem like you're being a pain, but you have a lot of legal liability when it comes to this. So it's better to be a pain right up front than have to try to figure things out when something doesn't go right. So.
And we have a question from the Mooresville office. So what if the original buyer refuses to let the seller have the report? How would the seller truly know what the problems were?
So that's a good question. And then, of course, we get asked this too about, well, who owns the report, and legally can the seller provide the report if technically they're not the ones that paid for it? And that's true. All of that comes into play. But I think that if you have a copy of the report, I think it's worth taking the risk that the home inspector is going to have an issue with you sharing that report and you didn't pay for it. I think that's worth risk. If they don't want to provide a report, and sometimes that happens, and if you feel like it was because there was issues that came up on that from that inspection, then the seller needs to pay to have an inspection done, is what they need to do. They need to have their own inspection done. Because obviously there was some kind of issue and they need further due diligence. It's definitely a red flag. If it looks and talks and walks like a red flag, then don't ignore it. Anybody else have any other questions?
I get a lot of questions about homicide. Is that a material fact?
That's unfortunate.
Well, I mean, believe it or not, I got at least 2 or 3 times this year that brokers called me with that question, and that somebody got shot in the house or somebody, passed away. I mean, which situation would be considered a material fact? If somebody got really ill and died in the house versus somebody got shot. And I guess this is one of the situations we actually had with a broker in our firm. It was not disclosed, and the neighbors, after moving to the new house, they started getting emails with copies of articles from a few years ago that somebody was murdered in that house, and it ended up being the case.
Yeah, so this is definitely a very complicated topic, and one that I have had personal experience with myself. And it's in this particular case, with this example, the courts in North Carolina have ruled that a homicide or a murder or death basically is not a material fact. So that makes it a little complicated for a listing agent, because you have a fiduciary obligation. You work for your seller's best interest. And so obviously disclosing something, like we tell you to agents, hey, err on the side of disclosure, but if it's really not in the best interest of your seller, then it gets really complicated.
You stigmatize the property.
Yeah, you're stigmatize the property, but yet it's like there's what the courts have said, and then there's what feels right. They're very, very tricky properties to sell. What I try to do is get my client to disclose it. Because you have to get their permission. Because then potentially, if you're going to disclose it, and it was something that your seller said to you, I do not want you to disclose, and the courts have said this is not a material fact, you're now running the risk of you're breaching your fiduciary obligation to your seller and not working in their best interest. So the best thing to try to do in that situation is really talk to the seller about disclosing it to potential buyers. Yeah.
It's Annie. Can I just give you one? Sorry, and I have been here since the beginning. I apologize.
Yes.
I couldn't get on as quick as I needed to. In this situation, just so you know, and again, every state is different, but I believe the only place where you do have the fiduciary duty is if you are specifically asked. So even if you're representing the seller, if the buyers ask you specifically and you have that knowledge, then you do have to disclose it. But otherwise, like you said, you kind of a tricky situation.
That is correct. Like you can't lie to somebody, but they're still like, can you refrain from saying anything? But then I think the bigger issue is the practicality is that, again, I list a lot of homes. It's rare that I have somebody that says, can you talk to me if somebody has died there? I'm not saying that I don't ever get it. I do, but it's not, it's something that doesn't happen very often. The same with pedophiles too.
Right.
You know, it's not something that buyer's agents ask. I don't get it very often, but
I've been working with Annie for over 10 years now. She knows we've had some cases that I feel comfortable to say there's no day that I can tell you I've seen it all.
yeah.
There's always another surprise out there.
So
Absolutely.
yeah, it's definitely, that one's very complicated. Annie Neal is with Real Estate Insurance Solutions. She's part of our E&O coverage group here at RE/MAX Executive. So Annie is an expert when it comes to your liability. So so now we have Annie on the phone. If we talked to agents already and said, if you think that you're in a situation, who do you go to? Who do you talk to? So what we have worked out is you talk to your broker in charge, you talk to Kuresh, and then Kuresh, you talk to Annie.
Correct.
Yeah. So
we have a protocol basically we follow every claim or potential claim, and I'd like to emphasize on that. You don't have to wait necessarily to be served or get papers for a lawsuit or to be summoned to disclose this. If you feel like you had a bad conversation or transaction and this can turn into an actual claim, you need to let us know. And what we do is usually put the insurance company, the E&O company, on notice. And the protocol is that you bring us the information. I'm not going to ask you to write a big novel about the case. Just give us some overall information about the case. We get the case submitted to our E&O company, put them on notice. We always get Annie involved. She's very experienced about the transactions. Side note about Annie, before getting involved in insurance business, she was actually a licensed broker for years. So she understands the business from both perspectives. And then once the claim is filed with the insurance company, if something comes up, our legal counsel of choice in Charlotte, which is Parker Poe & Associates, one of those attorneys, they will contact you to get more information, more detail about the transaction. And that's where you can actually tell them every little detail you like to share. So that's the process.
And Annie and I have talked about this, and Annie can speak more to it, but this isn't just for North Carolina Real Estate Commission inquiries. This is if you get an ethics complaint against you. It's a different procedure, is completely separate from the commission, but Annie and I have talked about how sometimes if the complaining party doesn't get the results that they want from an ethics complaint, that they'll step it up and they'll continue to seek other remedies. So it's better to take it seriously, even if I hate to minimize an ethics complaint, but it's definitely different than an inquiry. So I think that's all we had today. If you have any questions that you think of afterwards, just email us. You can email me, Gina, at yourpropertypeople.com. I'm happy to answer any questions you have, or you can call me, and I can talk to you about whatever specific situation you have.
Great. And we normally schedule risk management sessions for our group every year through Travelers. So they send their experts, and we normally invite all our legal counsel attorneys to be present to answer questions. I'm sure Sarah Robertson will get everybody informed about those sessions. We will have some training sessions and risk management sessions between now and the end of the year. We normally do that in a slower time of the year, so to respect everybody's schedule, to make sure that you guys can attend. So just look out for that. We'll definitely send out invitations, and we'll make sure that it gets communicated with everyone.
All right, everyone. Thanks for joining us, and until next week, happy sales.